Hi, I'm Will Hughes and I want to talk to you about the basics of construction contract law. The first thing is that construction contract law is nothing special. Contract law is the same in all business sectors. Contracts set out the rules of a business deal. But why do we need rules? Imagine a game of chess, for example. How would that work if you didn't have any rules? You wouldn't know what pieces to move. If you chose to move some pieces, the other person wouldn't know what you were doing. The whole thing just wouldn't work. So, like a game of chess, contracts set out the expectations of the parties. They tell you who will do what, how people will be paid, and so forth. In terms of defining who will do what, when we specify the work, we call that the scope. So a contract sets out an agreement on scope, on time, and on price. You've got these three things, you've got a business deal. So the contract records that, but the contract itself is also subject to rules of interpretation. It's part of the law of the land. And that raises the question about, well, what land are we talking about? In this course, we're talking about English law. In the United Kingdom, there are different laws in England, Scotland, and Northern Ireland. Wales uses the same law as English law. So we're talking about English law. We've also got to think about business behaviour, customs and practices. So as well as fitting into the context of the law of the land, a contract fits into the context of customs and practice when it comes to doing business. Now this is where things do start to get interesting, because custom and practice is different in each particular kind of industry. So there's three things that we need to understand when we're trying to understand a business deal in construction. We've got to understand what was in the agreement that the parties made. We've got to understand what the usual business practices are in that particular industry. And we've got to understand how the law of contract helps us to interpret the agreement that the parties have made within that context. Now, to be clear, what we're talking about here is business-to-business contracts, also known as B2B. These are different from consumer contracts, with which you might be more familiar. Now, consumer contracts are a special kind of contract because as an individual, you do not have as much economic power as a big business. So when you're buying things from a big business, if you have a dispute, they can afford better lawyers, they can afford court fees. You're going to have to struggle on your hands if you're going to take up a legal battle against a big business. So consumer law is there to protect us as individuals when we're in a dispute with big firms. But in a business-to-business contract, consumer law doesn't apply. We're not really interested in consumer law in this course, but you just need to be aware of the fact that your knowledge and understanding and experience of consumer law might mislead you into misinterpreting what would happen in business-to-business contracts. Now, you've also got to remember that commercial law applies to all business sectors. The courts are not going to make special interpretations that apply just to construction. So when we're looking at the law of contract, it's neutral when it comes to the business sector. But some industries do have industry-specific laws, and construction is no exception to that. We will touch upon those later in the course. So each transaction has got its own transaction-specific rules, and these are embodied in the contract, whether the contract's written out or not. Some rules are therefore implied into a contract, even if they're not in writing. And contracts do not exist in a vacuum, but in the context of commercial law. Interpreting contracts is important. It's important if you're in court having a dispute. The courts will come to a decision, and that decision will have an impact on the people who were in dispute. But it also has an impact even if you don't go to court, because it will help us to understand how to interpret the particular clauses that were under dispute in that particular case. So interpreting contracts is important. The structure of the courts, therefore, comes into play in trying to figure out our understanding of construction contract law. We've got to understand how the courts work, the hierarchy of the courts, the scope that the courts have for interpretation of the law, the significance of common law as opposed to civil law, and how a contract comes about so that it's recognised as such, as well as the terms and the conditions that might be implied simply because of the legal framework within which we're operating. So all of those are the kind of things that we're going to be covering through the next few episodes to set the groundwork for our understanding of construction contract law. Okay, that's it for now. See you next time.